Hi everyone, I am Lillian Chukura, the owner and lawyer at Lily Legal, where we help our clients get immigration status for themselves and for their families using the U.S. immigration law system. So today, I want to talk to you about how, well, mostly who US citizens and permanent residents can file for, right? That's a big question that I get all the time. I have clients that just became permanent residents and some that just became US citizens, and they're always wanting to know who can I file for? Can I file for my parents, my cousins, my siblings? Who can I file for? So today I will be going over who US citizens and permanent residents can file immigration petitions for. Okay, so if you have any questions about this or anything else, and you would like to schedule a confidential consultation with me, you can do so by going to my website, lilylegal.com, or by calling my office at 508-443-1788. The number is always on the screen, and all my contact details are in the description to this video. Now, like I said, most of my clients, once they become permanent residents or US citizens, this is the number one question they have. They typically have family members outside of the US or in the US that they want to file for, and they want to know if they can actually do it before we even get to how they will be able to do it. The first thing that we always want to do is figure out if they can actually file for the person, because sometimes the person you want to file for does not fit into the categories of people that a US citizen or a permanent resident can file for. Okay, so we are going to start with US citizens because they can file for the most amount of people, right? US citizens have the added benefit of not only filing for the people that permanent residents can file for, but they get additional bonuses of people that they can file for. So I am always excited to talk about this. If you have any questions about this or any immigration questions, put them in the comments. That's why I'm here. I'm here to answer your US immigration questions. So go ahead, pop your questions in the comments, and I will be answering those as I go along. And if you are watching this on the replay, go ahead, pop your questions in the comments so that I can respond to you later as well. So thank you so much for joining me. And I hope you are ready for this topic. Like I said, questions, put them in the comments. Let's have this chat about who US citizens and permanent residents can file for. Okay. So, starting with US citizens, this one is one of those that people always are not clear on. I've gotten questions about, can I file for my cousin? Can I file for my nieces and nephews? But unfortunately, there are limitations on who US citizens can file for. I know there's a lot of misinformation out there saying that once you file for one, once one immigrant gets citizenship, everyone in their family can now get citizenship. Unfortunately, it's not like that. So there are limits on who even US citizens can file for. So let's get into the first category of people that US citizens can file for, and that is their spouse, right? This is one of those situations where a US citizen is married to someone that is not either a permanent resident or a US citizen, and they want to file for them to get status. And if you are in this situation and you are a US citizen, just know you can file for your spouse as long as you meet all the other requirements. You can file for your spouse to get status in the US. If they're not already in the US, they can then come and join you in the US. Okay. Now, if you are also wanting to file for your children, there's an added benefit to US citizens. They can file for all their children. Okay, all their children, whether they are married, unmarried, over 21, under 21, have their own children, it doesn't matter. US citizens can file for their children to gain status. Now, I always say this with a little caveat. The only difference that the categorizations that I mentioned about if they are married versus unmarried, if they're over 21 versus under 21, the only difference that makes is how long is it actually going to take before they're able to get that visa, before they're able to get that green card. Okay, that's what's going to make the difference. So, like I said, US citizens can file for all their children, no matter their marital status or their age. And sometimes I get the question of, well, my child, now has their own children. Does that make a difference? No, it doesn't. It does not make a difference. So even if they're under 21 and they have children, as long as they're not married, they're still considered children under 21 of a US citizen. So they're still considered immediate relatives. Having children does not change their category. Being married changes the category, right? Being over 21 changes their category of how long it's going to take. But actually actually having their own children does not change that at all. So it's really good for people to know that, because like I said, I get that question a lot, and sometimes people think once their children have their own children, that's no longer a possibility for them to get status through their parents. But nope, they're the fact that they have their own children does not affect whether the parent that's a US citizen can actually file for them. Okay, so the next category of people that US citizens can file for are their parents. Okay, US citizens have this special privilege of being able to file for their parents that are not US citizens, that are not permanent residents, to gain status in the US. Parents are considered immediate relatives. So, what does that mean? If you are a parent of a US citizen in the US, you came in with a visa, but you overstayed your visa. If you are the parent of a US citizen and your US citizen child files for you, you can basically get your green card in the US without having to leave. Again, it all depends on your particular situation, but generally, if there's no negative issues in your case, you can get your status in the US through your US citizen child without having to leave the US. Okay, so US citizens can file for their parents. Now, there's another thing there. They can file for their parents, and that means either their biological parents, if they are adopted, their adoptive parents, or if they have a step parent, they can also file for the step parent. So in order to have that stepchild, step parent relationship, the marriage between your biological parent and your step parent has to take place before the child turns 18. Okay, as long as the marriage takes place before the child turns 18, the step parent is considered a step parent for US immigration purposes. So that's really the difference there. So, although technically, if you get married to someone and their children are 21, you're still considered their step parent. But for immigration purposes, that marriage has to take place before the child turns 18 for you to be able to get any benefits from the child. Okay, so that is the really important caveat when it comes to step parents, is that the marriage has to take place before the child turns 18. And then once that relationship is created, it is created. So even if you get divorced or anything like that, you're still considered a step parent. Excuse me. You're still considered a step parent, but you will then have to show that that relationship continued even after the divorce. Okay, so just keep that in mind. Now, after you are able to file for your parents, you are also able to file for your siblings. So this is something, again, unique to US citizens, right? US citizens have the added benefit of being able to file for their siblings. And this is great because one thing that I get all the time is people wondering, if they can file for their siblings, when they can file for their siblings, and how long is it going to take. Well, sibling petitions take a long time. Okay, I'm not going to lie to you. I'm not going to sugarcoat it. It takes a long time when you're filing for a sibling. It can take anywhere from 13 years to 14 years, depending on when you filed the petition. Okay, so if you file it today, you're probably going to be waiting about 13 to 14 years for that petition to be approved or for them to get the green card. That's really what you're waiting on. So even if you file today, they have a long wait time before they're able to actually get that green card. Now, now, because we're family here, I'm going to tell you the same thing I tell every single one of my clients when they are considering whether to file for their siblings or not. Yes, it's going to take time. Okay? Yes, it's going to take time. But think about it this way. Your sibling will probably get married, have their own children within that 13, 14 years, right? When they get that, when the visa becomes available for them, now, after that 13 years of waiting, not only can your sibling get a visa to the US, but now their children that are under 21, their spouse, can all get a visa to the US. So don't look at it as if you're just filing for your sibling and it's going to take forever. Think about it that you are potentially going to be changing your not just your siblings' life, but their children's lives, their spouses' lives. Like you can change the dynamic of an entire family by just filing for one person. So I always encourage it. If you are in that situation and you're trying to consider whether it's worth it to file for your sibling or not because of the wait time that they have to wait outside of the US before the visa becomes available, that's my advice to you. Think about what could happen in your sibling's life in the next 13 years, children that they could have that would benefit from your sibling eventually getting this visa. Okay? Think about that. The next thing that US citizens have the privilege of doing that no one else can do is they can file for a fiance. Yes, US citizens are the only category of people in the US that can file for a fiance. So you've met the person, you meet all the requirements for a fiance visa. If you haven't watched my fiance visa video, go ahead, pop over there and watch that because it goes into detail what those requirements are. But let me tell you, number one requirement is that you, the petitioner, is a US citizen. That's the first requirement. If you don't meet that requirement, I'm sorry, you cannot file for your fiance. That's how it works. It's special to US citizens, just like filing for parents and just like filing for siblings, okay? And filing for married children. But we'll get into that when we talk about who permanent residents can file for. Because, listen, even though permanent residents are not US citizens, they still have the ability to file for some of their family members to join them in the US, or if they're already in the US in valid status, to change their status to that of a permanent resident. So there is still rights and privileges that go along with being a permanent resident. However, if you do have the ability to become a citizen, those rights go up, right? The people that you can file for goes up. So let's go over again who US citizens can file for. Number one, they can file for their spouse. Okay. They can file for all their children, including the married ones. Okay. They can file for all their children, including the married ones. They can file for their parents. they can file for their siblings, and they can file for their fiance. The last three that I mentioned, the filing for parents, sibling, fiance, and married children, is unique to US citizens. They are the only ones that can do that. So if you are a US citizen, those are the people you can file for. Unfortunately, if you heard, if you followed along to what I said, I did not say that you can file for your cousins, your nephews, your nieces, any of those people. Even your grandparents, you cannot file for. You would have to, so in order to file for your grandparents, right, for the benefit to reach your grandparents, you would have to file for your parents, wait for your parents to become US citizens, and then they can file for their own parents. Okay, that's the only way that you as a US citizen can basically be able to have that have your status benefit your grandparents, is by filing for your parents and then having that reach their parents, your grandparents. Okay, so it is really, really hard for people to grasp that concept, that it's not really you get status, you become a citizen, and now all of a sudden your entire family, including your grandparents, even though there's some propaganda out there saying that that's what it is not. I'm sorry. I'm so sorry, but that's not what it is. You do have to meet the requirements, and if they don't fit into those categories, you can file for them. Now, for your nieces and nephews and cousins and all of that, if you can change them, right? If you can change their category from nieces and nephews to children, then you're able to file for them. So, what does that actually mean? So, you can adopt them if they still meet the requirements, right? If you meet the requirements of the country and of the US Immigration Services to be able to adopt them, you are able to do that. And then you can file for them as your children, your adopted children, right? But unless you're able to change their category from nieces and nephews to children, unfortunately, you cannot file for them to come to the US. Okay. So I just wanted to cover that because sometimes people want to know um, if it's possible for them to file for their nieces and nephews. And that's really the only way to file an immigrant visa, right? For them to get a green card directly through you, is for them to change that category from nieces and nephews to children. Now, there's a bunch of non-immigrant visas, like student visas, that they can come on, and you can sponsor them to study in the US if that's really the main reason for them to get that knowledge. And then they can always go back and um, start businesses or work over there with their um, degree that they received in the US, based on your sponsorship of them. But to actually get them a green card directly through you, like I said, you need to change their category from nieces and nephews to children. And if you want to learn more about that, you can watch my video on adoption and the immigration process, so that you know what you have to do to actually file for adoption and file the immigration paperwork for adoption. So that video is there for you if you want or need it. Okay, so now we are going to get into permanent residents, who they can file for. Like I said at the beginning, it's going to be a shorter list because, again, US citizens have more rights than permanent residents. So because of that, the list of people that permanent residents can actually file for is way, 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 way smaller. Okay. So permanent residents can file for their spouse. Right? Does that sound familiar? Same as US citizens. Permanent residents can file for their spouse. Now, they're not considered immediate relatives because that's reserved for US citizens. So that means if there's not a visa immediately available, they would have to wait. Sometimes before, the wait time used to be like a year or two. It can be longer than that depending on the basically the visa bulletin and how quickly cases are being processed. Okay. Recently, those have been current. So, US citizens and permanent residents can file for their spouse. US citizens and permanent residents can also file for their children. Now, the only difference is permanent residents cannot, permanent residents cannot file for their married children. Okay, let me let that sink in. Permanent residents cannot file for their married children. So once your child is married, unfortunately, you have to wait till you are a US citizen before you can file for them. Okay? If they're over 21, if they're under 21, you can file for them. Okay? The difference there is how long it's going to take. But once they get married, you have to be a US citizen to file for them. Now, what does this actually mean in practice? It means that if you are a permanent resident, let's say you have a 22-year-old child and you go ahead and start the process. You file for them. You know it's going to take about 5 to 6 years for a visa to become available. And while you're waiting for that 5 to 6 years, your child decides they're going to get married. And they actually go through the process of getting married. Unfortunately, they no longer qualify for that petition that you filed for them. Okay? So once your child gets married, even if you already started the visa process for them, even if you already started the visa process for them, if they get married before you become a US citizen, the whole process is canceled. They cannot move forward with the process once they get married. They would have to wait for you to become a US citizen and then start the process over again. I know I mentioned this and I stress it because I have seen it happen. Okay. I have seen it happen. So before you say there's ways around it, I have seen it happen. Okay. I have seen people get to the interview, the officer realize, oh, you're married now? Well, you don't qualify for this visa. So we're going to just cancel everything out. Your parents have to start over because you got married before they became a citizen. Now, if let's say you file for your child and before the 5 to 6 years is up, you became a citizen, and then a year after you become a citizen, your child decides to get married, you're still fine because they got married after. But their category is going to change. It's going to change to that of a married child of a US citizen, which means it's going to take much longer for them to get the visa. But because you were a citizen before they got married, you don't have to start all over again. That's the benefit of knowing this information so that you are not having to start all over again. Because that is the worst. Not only do you have to pay the fees again, but all those years you were waiting are now wasted because you have to start over. But if they got married after you became a citizen, those years will count towards however long the extra they have to wait because now they're married. So just know if your child is not married when you file and they get married before you become a citizen, that you will have to start the process over. Okay. So it's usually good. I typically, when my clients come in and they want to file for an older child that's not married yet, I do sit them down and I have this conversation with them. And I have them have this conversation with their child because you don't want to, you know, one thing with me is I want to make sure that everyone understands what the process is and what's required of them, because you don't want the the permanent resident parent to start the process and the child not knowing what is actually required, right? What the requirements are, go ahead and get married. and not even think about the visa process. Okay. So it's usually good to have this conversation, not just with the parent that's filing the petition, but also the child that the petition is being filed for, so that they can make that decision of, okay, do I just want to wait till you become a citizen so I can get married? Especially if they are already in the process of getting married, you might just have to wait till you become a citizen to start the process, because USCIS does not refund. Okay, there's no refund. Once they start processing your case, there is no refund. Whether your case is approved or denied, they do not refund that filing fee. So you really, really, really want to make sure that you are meeting the requirements and that your child knows what the requirements are, so that they don't inadvertently mess it up and now you have to start all over again, and those years of waiting just go away. Okay, so that is what I have for you today. If you have questions, go ahead and put them in the comments. Like I said, if you're watching this on the replay, welcome. As always, put your questions in the comments. I do go back and respond to your questions. I'm still getting questions on videos I did months and months ago, and I'm still going back and responding to those, because I know if you're watching the video and you have questions, those are important to you, and I want to make sure that I am responding to you. Okay, so go ahead, put your questions in the comments. And just a quick overview of what we covered today: US citizens can file for their spouse, all their children, including the married ones. They can file for their parents, their siblings, and their fiance. Permanent residents can file for their spouse and their unmarried children. Okay, their spouse and their unmarried children. Okay, so I hope you found this helpful. If that is all I have for you today. If you have any questions about this or anything else immigration related, and you want to book a confidential consultation with me, go ahead and do that by going to my website or by calling my office. All my contact details are in the description to this video. And I just want to thank you so much for your time. And remember, if you like this video, go ahead and hit the like button. If you know someone who needs to hear this, go ahead and share it with them. And if you are listening in a place where you can subscribe, then don't miss anything. Don't miss any of my uploads by going ahead and hitting the subscribe button. And if you have questions about this topic, go ahead and put it in the comments so that I can respond to you, and we can continue this chat. And once again, I am Lillian Chukura. I am the owner of Lily Legal, where we help our clients get status for themselves and for their families using the U.S. immigration law system. Thank you, and bye for now.